Hello everyone, welcome back to Bankruptcy 101. The information at the beginning of this video is extremely important, and the things that come afterward are the proof of what I'm going to say, and then the summary of all the things I will have said. First, we need to talk about who this video is for. Here's what the thumbnail looks like, but if you have a Fisker Ocean right now, it does not mean you're getting $14,000. In fact, if you are part of the group that I'm referencing in this video, you may not be getting $14,000. I'll explain all this. But the thumbnail says your claim, so in order to get that claim, you would have had to claim it. Here's what you would have needed to do. Complete official form 410 and timely file the claim on the docket. If you don't recall filing a proof of claim, which I also made a video about, here are my two videos: Fisker proof of claim, how to complete. Notice it also says official form 410, and then the proof of claim mailing. So if you didn't do this, this doesn't pertain to you. Enjoy your Fisker. So who does this pertain to? You bought a Fisker from Fisker, you filed a proof of claim, and you want to know how much money you're going to get from the bankruptcy settlement. And I have news for you. This is not going to be clear-cut, no matter what the information I'm about to provide from the document may suggest. Secured creditors like mortgage holders get paid first from their collateral. That's not us. Then priority unsecured creditors, taxes and support, which is lawyers and legal stuff. And finally, general unsecured creditors. That's us. Get what's left from non-exempt assets. And that's the big point here. We get what's left. Creditors with collateral get paid first. Again, those are secured creditors. We're not employees or the IRS, so we're not going to be priority unsecured claims either. There's a bunch of other priority unsecured claims, I'm sure, especially in a bankruptcy as complex as an automotive manufacturer. But even though we're not listed here in this generic explanation, we are this: general unsecured claims. And we must file a proof of claim to get paid from the bankruptcy estate. Also, we notice that Fisker is listed as Chapter 11, and neither of these are listed as Chapter 11. Well, there's a special type of Chapter 11 that we can look at, and this is the most important one to look at for us: is not shut down immediately. The business continues operation during the process until the plan is complete, unlike a quick Chapter 7 liquidation. And that was so continued activities, at least initially, like the fleet sale, could take place, and the cloud could continue to run. And the final reason is CVI Investments, which is the company that loaned them $400 million, resulting in $180 million in secured claims. That's important too, because those are going to be paid first. I think that's enough background. Let's talk about this document you got in the email. It's time for us to look at another one of these omnibus bankruptcy documents. We all got an email, and there are a lot of us, hence the 146 pages in the document in the email. Liquidating Trustee's 16th Omnibus Objection. To the holders of claims on Schedule 1, to the proposed order, annexed hereto as Exhibit A. Let me go straight down to my name and show you what I'm talking about. As I suggested in a previous video, because your claim may be adjusted regardless of what amount you enter, I suggested you use unliquidated, which I did. This is my actual line item right here. This line is me. And this number is important: $14,296. Upon review of the claim, the liquidating trustee determined that the claim seeks damages for loss of vehicle warranty. Accordingly, the claim should be reduced and fixed, and or liquidated and fixed as applicable, as a general unsecured claim in the amount of $14,296. Additionally, the claimant fails to attach documents sufficient to support any claim for damages beyond the loss of vehicle warranty. So for me, this is going to be it. That's what I'm after: vehicle warranty loss. That in mind, now we can go back up to the top and see what they want from us. You are directed to locate your claim attached to the proposed order. I just did that. Most of us owners, or folks in our position of single ownership of a vehicle, have probably been adjusted to $14,296. The liquidating trustee, that's Matt Dundon, hereby submits this 16th omnibus objection seeking entry of an order substantially in the form of Exhibit A. So we were looking at that. Rules of the bankruptcy procedure and Rule 3007 of the local rules, reducing and fixing, or liquidating and fixing as applicable, the overstated claims listed on Schedule 1 to the proposed order, the overstated claims or the disputed claims. In support of the objection, the liquidating trustee submits the declaration of Rick Wright, C. Right declaration, a copy of which is attached here too as Exhibit B. Let's go to Exhibit B, Right declaration. I submit this declaration in support of the liquidating trustee's 16th omnibus objection. All matters set forth are based on my personal knowledge, my review of the documents, my view based on my experience, information supplied to me by others at my request, and as to matters involving United States bankruptcy law or rules or other applicable laws, my reliance on the advice of counsel or other advisors to the liquidating trustee. During the claims and interest reconciliation process, the reviewing parties have conducted and continue to conduct a review of the proofs of claim filed in Chapter 11 cases. In this regard, I or another person at my discretion participated in the review of the overstated claims listed on Schedule 1 and first determined that such claims seek damages for the loss of value of the new vehicle limited warranty provided by the debtors at the time of the applicable claimant's vehicle purchase. In order to properly evaluate the validity of the overstated claims, the liquidating trustee retained Berkeley Research Group to provide an expert opinion. In reliance upon the expert opinion set forth by BRG in the Mathau Declaration as to the value of the warranty, the liquidating trustee next determined that the overstated claims are objectionable on substantive grounds, as each were filed in an incorrect or unliquidated amount based on loss of warranty value and should be reduced and fixed, or liquidated and fixed, as applicable. More specifically, in an effort to promote fairness and to provide each claimant listed on Schedule 1 to the proposed order with an opportunity to receive a reasonable recovery under the circumstances of these Chapter 11 cases based on such claimant's loss of warranty, the liquidating trustee seeks to reduce and fix each of the overstated claims at the highest end of the range of value of the warranty determined by BRG as set forth in the Mathau Declaration, which is 14,296. That's the number on Schedule 1 for most of us. If your box to the far right said what my box said, then that means you. Further, to the best of my knowledge and belief, and based on the information in books and records available to me, failure to reduce and fix the overstated claims at warranty value could result in the applicable claimant receiving an unwarranted recovery against the debtor's estates to the detriment of other creditors. Accordingly, I believe that the court should grant the relief requested in the objection with respect to the overstated claims. Conclusion. Accordingly, based on my review of the claims register, the books and records, and the Mathau Declaration, I believe that the granting relief requested in the objection is in the best interest of the liquidating trustee, the debtors, estates, and their creditors. So, 14,296 for loss of warranty. Next is the Mathau Declaration, which is Exhibit C, which we can look at. Here's the Mathau Declaration. My curriculum is attached on Appendix B, which is the research that he did. I have reviewed the information listed in Appendix C, which is also below. We can look at these. But he kind of sums it up in number 7. If called upon to testify, I could and would testify completely to the facts set forth herein. Based on the analyses detailed in this declaration, assuming historical warranty repair costs apply, or either the high voltage battery or both electric drive units need replaced, the estimated value of the warranty provided to the owner of a Fisker ranges between $9,100 and that $14,296. And that's high voltage battery replacement, front and rear electric drive units, and forecasts based on actual warranty costs from Q4 of 23 and Q1 of 24. So if you want to know why $14,000 was chosen, that's why. He is not telling you your vehicle is only worth $14,000. He is telling you the value of your warranty should the most catastrophic stuff happen is $14,000. And it goes into detail. It's math based on the kilowatt hours and the average pack replacements. Here's your gross battery capacity and your estimated battery replacement cost. Labor cost was added to the parts to determine total replacement cost. Number 12, a replacement cost approach was applied to the electric drive units which serve as the propulsion source in Fisker vehicles. You got EDU replacement, $31.39. Internal parts cost per vehicle, $62.78. Expected consumer cost, $91.03. Both drive units, $10,883. More forecasting of costs, projected labor and parts costs through the life of the standard warranty, which terminated after 2029, equal $52,613,415. That's $52,613,415. Dividing by 5765 yields $91.26. I was also asked to compare the market value of a 23 Ocean to comparable EVs in number 18. Here's your comparable EVs: Model Y, R1S, I-Pace, Lyriq, Mach-E, Q4 e-tron, EQB, GV60iX. Not bad comparisons. 19 different trims and packages were identified. The first step of this analysis was to calculate the average market value decline and average mileage, which they got 12,061 for the average and 12,330 for the median. Average list price, 19,180, while the average purchase price recorded, 71,160. That's a 73% decline in value on your Ocean valuation. Next, Fisker's decline in market value was compared to the decline in market value of other EVs. Looks like we got 39.8% on the Model Y long range. For trade-in, private party 38.5%. Performance, it's 40.9 and 38.7. And then table 5, expected diminution in value. Fisker Ocean expected diminution in value, 23,560. Same calculation was applied to each of the 9 comparables. The average incremental difference in value relative to all comparable models is 15,937 per vehicle based on trade-in, 19,316 based on private party. Fisker reported a warranty reserve of 7,054,000 at year-end 2023 with 4,847 vehicles delivered. Automotive manufacturers generally record a single warranty reserve in the period of sale for each vehicle rather than booking additional amounts in subsequent years for the same car. Dividing 7,054,000 by 4,847 yields a warranty per vehicle cost of $1,455, which therefore represents the total expected cost of an individual warranty to Fisker. 100% markup on the vehicle cost yields a warranty per vehicle $2,910. This amount below is the calculated range for a Fisker vehicle warranty, further supporting the reasonableness and fairness of the established valuation range. Battery replacement, $14,296. That's the number proposed. Electric drive unit cost, we went over these. And then it's the pre-order agreement, which holds a special place in my heart because it was my first Fisker video. I literally read this on the internet, and it goes through all of Fisker's stuff. Cooling off notice, payment terms. So all the stuff you agreed to, just a bunch of Fisker documents. Let's go back to the top. Now that we've looked at the right declaration, which decides that $14,296 is legit, and the Mathal declaration, which is the guy that did that math. This is a summary of who did what, your petition date, your debtors, the combined disclosure and Chapter 11 plan of liquidation. On October 16th, the court entered the findings of fact, conclusions of law and order approving the disclosure statement on a final basis. That gave us the ability to disclose and opt out. I hope you guys remember that. October 17th was the effective date of that in number 8, and the plan went effective. The liquidating trust was established. The plan provides that after the effective date, the liquidating trustee shall have the sole authority to file, withdraw, or litigate to judgment objections to claims, other than a professional fee claim. This is all just a summary of what happened. We might as well go back over it. It's been a while. August 15th and 16th, each debtor filed its respective schedule of assets and liabilities. August 19th, the court entered its order establishing certain bar dates for filing proofs of claim. That's us, September 11th, 2024, 5 p.m., to file proof of claim. This may be pertinent. Letter E, claims objection procedures. In connection with the claims and interests reconciliation process, the liquidating trustee obtained approval of certain substantive omnibus objection procedures intended to promote a reconciliation process that is conducted in a timely, efficient, and cost-effective manner. In the ordinary course of business, the debtors maintained books and records that reflect, among other things, the debtors' liabilities and the amount owed to their creditors. That's us. Unsecured creditors. The liquidating trustee and his advisors, the reviewing parties, have been and continue to undertake a comprehensive review of all claims and interests filed in these Chapter 11 cases. Since the effective date, the liquidating trustee has filed numerous omnibus objections to claims and or interests, and here's all the documents if you want to go read all those objections. In addition to and as part of the formal claims and interest reconciliation process, the liquidating trustee continues to resolve certain outstanding claims and interests through stipulated withdrawals, settlements, and or consensual reconciliations. F. Overstated warranty claims. The liquidating trustee reviewed the overstated claims on Schedule 1 to the proposed order, that's us, and first determined that such claims seek damages for loss of value of the new vehicle limited warranty provided by the debtors at the time of the applicable claimant's vehicle purchase. In order to properly evaluate and reconcile the overstated claims, the liquidating trustee retained Berkeley Research Group. Those are those 2 exhibits we already looked at. Upon the expert opinion set forth in the Mathal Declaration with respect to the value of the warranty, the liquidating trustee next determined that the overstated claims are objectionable on substantive grounds and should be reduced and fixed, or liquidated and fixed as applicable, as set forth to the proposed order. More specifically, in an effort to promote fairness and provide each claimant listed on Schedule 1 to the proposed order with an opportunity to receive a reasonable recovery under the circumstances of these Chapter 11 cases based on such claimant's loss of warranty, the liquidating trustee seeks to reduce and fix or liquidate and fix, as applicable, each of the overstated claims to the highest end of the range. That's that same 14,296 we were talking about. Number 33, relief requested by this objection and for the reasons described more fully herein, the liquidating trustee objects to the overstated claims on Schedule 1 to the proposed order. In that regard, the liquidating trustee respectfully requests entry of the proposed order reducing and fixing each of the overstated claims to warranty value as set forth more fully on Schedule 1 to the proposed order. So I think that's the liquidating trustee requesting that 14,296 is what we get. Claim or interest, proof of which is filed under Section 501 of the Bankruptcy Code, is deemed allowed unless a party in interest objects. I think we're finally getting to the nuts and bolts here. Further, Bankruptcy Code Section 502B provides that a court shall determine the amount of such claim as of the date of the filing of the petition and shall allow each such claim in such amount except to the extent that such claim is unenforceable against the debtor and the property of the debtor. So 502A says the court determines the amount, which they've done. That's that fix or liquidate and fix. 35. The burden of proof for determining the validity of claims rests on different parties at different stages of the objection process. By completing official Form 410 and timely filing the claim on the docket, a proof of claim is deemed to be an allowed claim unless an objection is interposed. The filing of a proof of claim thus shifts the burden to the objector to prove why the claim should not be allowed. Basically, if we're on this list, our claim is in there, and they've adjusted it to 14,296. Once the prima facie validity of a claim is rebutted, it is for the claimant to prove his claim, not for the objector to disprove it. So, I think what 35 and 6 are saying is that right now, if you like the amount, you're good to go. But once the claim is rebutted, it's on you to figure out what the real amount is and defend your claim, and basically it's on you. 38, for the reasons set forth herein, there is ample evidence to rebut the prima facie validity of each of the overstated claims. Specifically, the liquidating trustee reviewed the overstated claims list on Schedule 1 to the proposed order and first determined that such claims seek damages for loss of warranty value. In reliance upon the expert opinion set forth by DRG to the value of the warranty, the liquidating trustee next determined that the overstated claims are objectionable on substantive grounds, were each filed in an incorrect or unliquidated amount based on loss of warranty and should be reduced and fixed or liquidated and fixed as applicable at warranty value, i.e. the highest end of the range of the value of the warranty. This is all that 14,296. Failure to modify or disallow and expunge as applicable the overstated claims at warranty value could result in each claimant receiving an excessive recovery against the debtor's estates to the detriment of other creditors. Accordingly, the liquidating trustee objects to the allowance of the overstated claims and seeks entry of an order reducing the amount of the overstated claims to the proposed order under heading modified claim amount. 43. Therefore, pursuant to Bankruptcy Code 502B, Section 1, Bankruptcy Rule 3007, Local Rule 3007-1, Section C, and the claims objection procedures, the liquidating trustee respectfully requests that the court enter the proposed order granting the relief requested herein. Holy moly, are we getting 14,296? Responses to omnibus objections. 44. To contest this objection, the holders of the overstated claims listed on Schedule 1 must file and serve a written response so that it is received no later than February 5th, 2026 at 4 p.m., the response deadline. The response must be filed with the Office of the Clerk of the United States Bankruptcy Court for the District of Delaware. There's the address, 824 North Market Street, Wilmington, and served upon counsel to the liquidating trustee, so that the response is received no later than the response deadline. So that's a receipt date and time. February 5th, 2026, 4 p.m., and it's your responsibility to get it to him in that amount of time. Every response to this objection must contain, at minimum, the following information. Here we go. A caption setting forth the name of the court, name of the debtors, the case number, and the title of the objection to which response is directed. The name of the claimant, claim number, description of the basis of the claim, the specific factual basis and supporting legal argument upon which the party will rely in opposing this objection. Any supporting documentation to the extent it was not included with the proof of claim previously filed with the clerk or claims agent upon which the party will rely to support the basis for and amounts assessed in the proof of claim, and the name, address, address, telephone number, email address, and fax number of the persons which may be the claimant or the claimant's legal representative with whom the counsel for the liquidating trust should communicate with respect to the claim and or the objection, who possesses authority to reconcile, settle, or otherwise resolve the objection to the overstated claim on behalf of the claimant. 46. If a claimant fails to file and serve a timely response to the response deadline, the liquidating trustee will present to the court an appropriate order reducing and fixing the overstated claims without further notice to the claimant. Consistent with Local Rule 9006, the liquidating trustee may, at his option, file and serve a reply to a response no later than 4 p.m., 1 day prior to the deadline for filing the agenda for any hearing to consider the objection. Separate contested matters. Each of the above objections to the overstated claims constitute a separate contested matter as contemplated by Bankruptcy Rule 9014. The liquidating trustee requests any order entered by this court with respect to an objection asserted in this objection shall be deemed a separate order with respect to each claim. Reservation of rights. 49. The liquidating trustee expressly reserves the right to amend, modify, or supplement this objection and to file additional objections on any applicable grounds to the overstated claims or any other claims which may be asserted against the debtors and or the liquidating trust. Should one or more of the grounds of objection stated in this objection be dismissed, the liquidating trustee reserve his rights to object on other stated grounds or on any other grounds that the liquidating trustee discovers during the pendency of these Chapter 11 cases. Notice of this objection has been provided via first-class mail and email, if available, to the Office of the United States Trustee for the District of Delaware and all claimants on Schedule 1 to the proposed order or their counsel, if known, and any persons who have filed a request for notice in these cases pursuant to Bankruptcy Rule 2002. Conclusion. 52. Accordingly, the liquidating trustee respectfully requests that this court enter the proposed order attached hereto as Exhibit A, reducing and fixing the overstated claims, and grant such other and further relief as is just and proper. Holy moly, they've got the amount. It's $14,296, unless you want to object, and in that case, you've got until early February to do so. Okay, so that was a lot, but I figure if you've made it this far, you're really here to answer this question. Where's my money? And before you get paid, other people have to get paid first. The biggest one being CVI Investments. That's $180 million in the event that exists. That's a secured claim, which means Fisker signed an IOU saying they owed CVI Investments that money. It was a very predatory loan, and CVI Investments was able to, one step at a time, dismantle, destroy, and eliminate Fisker overnight, while, and this is a theory for me and an opinion, possibly also shorting the stock to collect money on said demise. So in the event that goes really well and there's still a ton of money left, taxes, wages, and official stuff will be paid. Those are priority unsecured claims. And no, you haven't gotten any money yet. After that, you get paid. Remember, if there's anything left. And I don't have a ton of theories about how much money we're going to get. In fact, I don't think I'll say anything verbally about how much money we're probably going to get. But there is some data on this, I'm sure. Let's check. Unsecured creditors often receive little to nothing, typically getting only pennies on the dollar, if anything, in bankruptcies, especially Chapter 7, which is a liquidation, which is what we're doing, where most unsecured debt is discharged. Thank you all for your support over the years. I really appreciate it. Join Patreon or become a YouTube member for early access to videos. Here's the real ending.
Hey! Smash the like button!
Thank you.